Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we turn our attention to the great state of Florida, which, as was reminded to us yesterday in the case regarding the Ballerina murderer, who was convicted of manslaughter, Florida uses six-person criminal juries in all cases except for death penalty cases, which is an aberration as it relates to such things. Many states use six-person juries for misdemeanors, but I believe Florida is alone on this issue, where they use six-person juries for felonies, especially serious felonies, especially murder. Not normal. Florida just does the six-person juries. Now, I was trying to find out why they adopted six-person juries in the first place, but I couldn't find the historical reason. So I'm not sure why they did it, but they did do it. For some reason, they said, we're going to only have six-person juries in criminal cases. So the U.S. Supreme Court was asked to decide this issue many moons ago. So we're going to read this decision from the 1970s, where the Supreme Court analyzes whether or not this is constitutional to have six-person criminal juries, at least as it relates to felonies. And then we'll read a dissent from Neil Gorsuch in a case that denied the writ for cert, but he dissented from the refusal to take the case, saying that the court should re-examine this issue. So we're going to go ahead and discuss that. So fine. We pick it up in the Supreme Court decision of Williams versus Florida. We pick it up in Section 2. Section 1, by the way, dealt with a different issue. It dealt with whether or not a defendant needs to give notice of an alibi. They do. Moving on to how many people have to be in a jury. Issue number 2. In Duncan versus Louisiana, 1968, the Supreme Court, held the 14th Amendment guarantees a right to trial by jury in all criminal cases that, were they to be tried in federal court, would come with a Sixth Amendment guarantee. Okay, so we're dealing with incorporation, the incorporation of the Bill of Rights. The Bill of Rights, because the Supreme Court nuked the Privileges or Immunities Clause in the slaughterhouse cases, has had to been applied piece by piece and clause by clause in the process of incorporation in the idea of substantive due process. And as part of that process, do the rights apply to the states at all? Incidentally, the Supreme Court has said some of the rights do not apply to the states, or are not required to be applied to the states, maybe is a better way to put it. Such things that do not or do not apply to states, such things that are not incorporated, include grand juries. States do not have to have grand juries. The federal government does. The states do not. It's optional for the states. Half the states have them, half the states don't. The states that have them, some of them use them more routinely, some less. It's up to them. Another thing that has not been held to be applicable is the $20 minimum for the civil trials. And also, of course, the Third Amendment with the quartering of troops, because there's not a lot of case law on that issue. But every time they've had to incorporate any other provision of the Constitution, there's always been this question, literally every single time. Hey, is it the same thing that the federal government is, or is it a different thing? So this is this two-track idea that you'll sometimes see discussed in the case law. You saw it discussed, for example, when it came to the Second Amendment, when Heller was being decided, or more to the point, McDonald, because McDonald was the case that applied it to the states. So you saw this in McDonald when they were trying to decide, does it apply to the states? They're trying to say, okay, is the Second Amendment that applies to the states, is it the same thing, or is it a different thing? Or to put it maybe slightly differently, hey, when they did this thing in the 14th Amendment, were they changing what it was, or were they simply adopting what had been done in the original thing? So when they passed the 14th Amendment, right, presumably they could have been changing something by the 14th Amendment, because it's an amendment. So the question is, does the 14th Amendment change the substance, for example, the First Amendment, or the Second Amendment, or any other amendment? Literally every single time this question's been asked, the answer has been no. We have never done the two-track thing, and God thanks for that. We don't need more things in our life. Okay? So whatever the First Amendment means, it means the exact same thing if we're in federal law or we were trying to apply it to state-specific action. So we can have a debate about what it means, but it only means one thing. It doesn't mean two things. It doesn't mean something different if we're asking the federal government versus the state. It only means one thing. And thank God for that. Makes our life simpler. So this issue came up when it came to this issue too. Okay, there's a right to trial by jury. The states are also bound by this. They have the right to a trial by jury. Is that the same thing? Is that the same thing as it is for the federal government? And the Supreme Court said, yes, it is. It's the same thing. So they are exactly parallel. They're one for one. Whatever it means for the federal government is what it means for the state government. If you have the right to it in the federal government, you have the right to it in state government. Great. Moving on. Petitioner's trial for robbery in this particular case that we're discussing today happened in 1968. Clearly falls within the scope of that holding. Fantastic. If you were being tried by the federal government for robbery, you'd have a right to trial by jury. So you have a right to trial by jury by Florida too. Cool. The question in this case, however, concerns whether the constitutional guarantee of the trial by jury necessarily requires the trial to be exactly 12 persons, as opposed to some lesser number, in this case 6. So does the number have to be 12? The Supreme Court saying, we hold that a 12-person panel is not a necessary ingredient of the trial by jury, and respondents' refusal to impanel more than 6 members provided for by Florida law did not violate petitioner's Sixth Amendment rights as applied to the states through the 14th Amendment. So again, they are parallel. So no, you don't have to have 12-person juries as a matter of constitutional guarantee, according to the Supreme Court's decision in the 1970s. Now, I will point out, of course, that in addition to Gorsuch, which we will discuss in addition to Gorsuch, this decision has been criticized, as you might imagine. And so there's that issue. And to what number is the minimum allowed is also debatable. Because if 6, why not 5? Or why not 4? Or why not 1? So that's also an issue. So they said 6 is sufficient. How about some lesser number? And if the answer is 6 is required, where does that number come from? As opposed to 12. So there's definitely unanswered questions to be had there. Okay. We had occasion in Duncan versus Louisiana to review briefly the oft-told history of the development of the trial by jury in criminal cases. That history reveals a long tradition, attaching great importance to the concept of relying on a body of one's peers. And this idea of peerage, by the way, is an interesting concept because in America, everyone's your peer. Because that was one of the points of the American system, as opposed to the UK system, or for that matter, other systems in which there are literal legal castes, right? The lords are better than you in a very legal sense. They are not your peer. They are better than you. They are not the same as you. But in the American system, of course, we abolished this concept. We don't have a caste system. Everyone is equal. Everyone is your peer. Cool. But in any case, whoever the body of your peers happen to be is a safeguard against arbitrary law enforcement. Cool. That same history, however, affords little insight into considerations that gradually led to the size of the body to be generally fixed at 12. Okay. I mean, fine. We don't know why 12, but why 12 historically. Now, as to but why 6 in Florida, I imagine one could find the answer. You would have to presumably go into the debates in the Florida legislature and look at the debates that were being had by the legislators as to why but 6 though. I presume that there are records. So if you want to know why 6 though, as Florida, why did they make that decision? I assume it could be discovered with adequate research. However, apparently when it came to the question of why 12 though, as a matter of common law, we're like, and it just kind of happened. But, fair enough, is sort of as far as it goes. It just kind of happened. It just became a thing. And if something happens long enough, then maybe that is just what it is now. It is defined by its practice. It's defined by its practice. Why is this how it came to be? Is perhaps less interesting in some situations rather than it is. It just is that way, and it is that way, and it's been done that way, and that's just the way to do it. And if you want to change it, then presumably you have to come up with a reason to do it. So it's not necessarily to say it could be fixed all of time, necessarily, but we've been doing it this way, and that's the way common law works typically. So if we've been doing it long enough and consistently enough, that just becomes the law because of practice. That would typically be the answer. So, okay, we can't figure out why, it just happened. Fine. Some have suggested the number 12 was fixed upon simply because that was the number of presentment of a jury from the 100, of which the petite jury developed. Okay. So, fine. And that also traces to when juries had different functions, because juries did different things at different times. So, apparently, there was at some time something called a presentment jury, and it had 100 people in it. And 12 people apparently spoke for that jury. And apparently that jury was basically an inquisition, which I guess makes it a grand jury of some kind in our modern parlance. So we have 100-person, because grand juries can do this today, by the way. They don't necessarily, but they can, depending on the relevant state law. But grand juries can serve an investigative function, as opposed to just hearing a case brought by a prosecutor. So the majority is the prosecutor brings essentially the case completed to the grand jury and is like, will you vote on the indictment? But grand juries can serve an investigative function. So they can be asked to look into something without necessarily any clear defendant in mind from the start. They can be used to discover potential defendants. They're an investigative tool. They have been historically used as an investigative tool. Of course, these days, typically, you use the police more for such purposes. Typically, the police now are the ones that do the investigation. But historically, grand juries could also do this, and sometimes they're still used for that purpose. So apparently, in antiquity, there was some kind of 100-person something that resembled a grand jury. This 100-person grand jury inquisition thing, whatever. And 12 people spoke for that group because reasons. Cool. Fine. Other, less circular, but more fanciful reasons for the number 12 have been given, but they were all brought forward after the number was fixed, which comes from the Bible, and the rest little more than mystical or superstitious insights into the significance of 12. Lord Coke's insight that the number 12 is much respected in the Holy Writ as 12 apostles, 12 stones, 12 tribes is typical. Sure, fine. In short, while some in the 14th century, the size of the jury came generally to be fixed at 12, that particular feature of the jury system appears to have been a historical accident, unrelated to the great purpose for which the jury was found in the first place. Yeah, but be that as it may, if it were fixed by the time of the 14th century, I would be like, but it's fixed though. And so when, again, you're trying to understand what a provision in the Constitution refers to. And they talk about the right to a trial by jury. We know that word that's an antecedent. That's a specific defined antecedent, the word It's a specific thing, the right to a trial by jury. It's not a right to a trial by jury, it's the right to a trial by jury. The specific right. Well, how do you know what that is? History and tradition is the way you do that. That's the way you do it basically for any of the constitutional rights. Or for that matter, you would do it for a statute or a regulation, or basically anything that you were trying to interpret. Because understanding how something came to be will help you understand what it is, potentially. So understanding the history of the thing helps you understand what it is. And so if we understand that by the 14th century, 12 was the number, then, by the 18th century, when they're writing the Constitution and the Bill of Rights, 400 years later, then that's probably what they meant. Why 12? Who cares? To some degree, it just is. But the Supreme Court's like, we can't figure out the reason, so we're going to ignore it because it doesn't matter. I am not sold by this reasoning. The court's earlier decisions have assumed the affirmative answer to this question. The leading case about whether it's an accident, or they say the question before us is whether the accidental feature has been immutably codified. I would say yes. I would say yes. But yeah. The court's earlier decisions have assumed the affirmative. I would think so. The leading case on this, construing the Sixth Amendment, is Thompson v. Utah. There, the defendant had been tried and convicted by a 12-man jury for the crime committed in the territory of Utah, because Utah's not a state at this time. A new trial was granted, but by that time, Utah had been admitted as a state. Huzzah! The defendant's new trial proceeded under Utah's constitution, providing for a jury of only 8 members. The court reversed the resulting conviction, holding that Utah's constitutional provision was ex post facto law as applied to the defendant. Well, that's really interesting, incidentally, on a legal framework about ex post facto or not. That's an interesting one, because you're basically fundamentally changing legal status in a fundamental way. So that's an interesting curiosity about whether or not that's ex post facto or not. It's the state of Utah has just been created just now. So is it ex post facto? I guess. So the states are bound by the actions of their territories, which is, to be fair, true in the law, generally speaking. And incidentally, this came up recently in Arizona when it came to the abortion ban, as it was returned to the states, because Arizona had a judicial decision or a statute, I forget exactly, but they had something on the books from them when they were still the territory of Arizona. And is typical, those decisions carry over. Incidentally, this would carry over relating to the states before they were states, generally speaking, because, before they were states, they were just colonies or they were just whatever. And of course, they inherit all the common law that came before. So their status to become states did not abrogate the history of the law, and they were bound by that because largely the constitutions themselves were adopting it in the first place. So they ratified it. So that makes sense. So they say ex post facto, but I do note the curiosity there. It's like Utah's being bound by something other than the state of Utah, which is kind of funny. All right. In reaching the conclusion in that case, the court announced the Sixth Amendment was applicable to the defendant's trial when Utah was a territory. Fine. So does the Constitution apply to territories? They say yes for Utah, but not so much necessarily for territories today. Incidentally, see the insular cases on that issue. The Constitution does not necessarily apply in full faith and full measure to the territories of the United States. I'm looking at you, Puerto Rico. So they said the Constitution fully, at least this provision of it, applies to Utah. But if you're asking about Puerto Rico because it's a territory, the answer is not necessarily yes. See the insular cases. I don't support the insular cases, but they are what they are. Even the insular cases, by their own definition, said they were only supposed to last for a time. And that was 100 years ago. I guess nothing is as permanent as a temporary government solution. Am I right? Anyways. But I digress. So in any event, this particular guarantee, Utah, the territory, had to apply to, it had to agree to. And because it's something Utah, the territory, was bound by, Utah, the state, was bound by it. Okay, fine. And the jury referred to in the amendment was a jury constituted as it was common law of 12 persons. That would be the common law. Arguably unnecessary for the result. I'm not sure that's an interesting idea, but okay. This announcement was supported simply by referring to Magna Carta. It does come up. And quoting passages from treatises, which noted, as has already been seen, that a common law, the jury did indeed consist of 12, which is kind of enough for me. C is for cookie. That's good enough for me. It is because it is. Sometimes that's just the answer. And that's the legal answer. But the Supreme Court wants to be different for some reason. Notably absent was any discussion of the essential step in the argument, namely that every feature of the jury as it then existed at common law, whether incidental or essential, was necessarily to be included in the Constitution. But why wouldn't it be? Why wouldn't it be? Yeah. Subsequent decisions have reaffirmed the announcement in Thompson, often in dictum and usually by relying. Were there any discussion of the issue at all, solely on the fact that common law decided consisted of 12? Yeah, but it did, though. While the intent of the framers is often an elusive quarry, trying to figure out what they meant can sometimes be challenging. To be sure, it can be challenging sometimes. The relevant constitutional history casts considerable doubt on the easy assumption in our past decisions that if a given feature existed at a jury at common law in 1789, it was necessarily preserved. Why wouldn't it be, though? Because that defines the jury. Why wouldn't it be? Because they're referring to the right of the trial. They're referring to the right of the trial by jury. So if what the jury was a static understanding in 1789, then that's probably what they were referring to. Yeah. It was necessarily preserved in the Constitution. Provisions for jury trial were first placed in the Constitution of Article 3's provisions that the trial of all crimes shall be tried by jury. And in such trial, the case shall be held in the state where the crimes shall have been committed. Cool. The very scanty history of the provision in the records of the Constitutional Convention sheds little light either way on the intended correlation between Article 3's juries and the feature of jury at common law. But they're using the word. So I would think, assume they mean the same thing, unless there's a reason not to. But we're not sure what the correlation is, but it's the same exact word. So sure, the Constitution could be referring to something different, but what's your basis for concluding it's referring to something different? And if it's not referring to something different, and you can't find evidence referring to something different, it's probably referring to the same thing, because they're using a defined concept. So that's kind of a dumb argument by the Supreme Court, in my humble opinion. Indeed, pending and after the adoption of the Constitution, fears were expressed that Article 3's provision failed to preserve the common right to be tried by a jury of the vicinage, which is a very fancy term for jurisdiction. The vicinage is a very fancy term for the jurisdiction in the place where the crime happened, which is a slightly narrower concept than the state. But it's the territory in which it happened. Anyways, pressing on. That concern, as well as the concern to the trial by the right of a jury in a civil as well as criminal case, furnished part of the impetus for inducing amendments to the Constitution that ultimately resulted in jury provisions in the 6th and 7th Amendment. As introduced by James Madison, the amendment to jury trial in criminal cases provides that the trial of all crimes shall be by an impartial jury of freeholders of the vicinage, with the requisite of unanimity for conviction, of the right of challenge and other custom requisites. Fine. Yeah, vicinage sounds like an archanism for vicinity. You got it. Same root word. You got it. It is. It's the exact same word. It's vicinity. You got it. I could just say vicinity. You got it. But it's the same root word, same kind of fundamental concept. The amendment passed the House in substantially this form, but after more than a week of debate, it returned to the House considerably altered. So this was one of the proposals for the Constitution, and then they changed the wording along the way, as one does. While records of the actual debate that occurred in the Senate are not available, a letter to Madison to Pendleton in 1789 indicates that one of the Senate's major objections was to the vicinage requirement of the House version. A conference committee was appointed. As reported in the second letter, the Senate remained opposed to the vicinage requirement, partially because its view by the then pending judiciary bill, which was debated at the same time of the amendment, adequately preserved the common law vicinage feature, making it unnecessary to freeze that requirement in the Constitution. So they're like, we don't need to do it in Constitution because we're going to do it in a bill, but we don't need to freeze it in place. Okay. I mean, fine. You're debating what is and is not fundamentally required as you debate the constitutional article. Fine. So someone thought this was required. Someone thought this was not required. Fine. They're having a debate about it. Cool. The Senate, wrote Madison, are inflexible in opposing a definition of the locality of juries. The vicinage, they contend, is either too vague or too strict. Too vague if depending on the limits to be fixed by the pleasure of law, too strict if limited to the county. Yeah, and obviously you can determine why this might be a problem, because if you were fixed to the vicinage, then you might have a problem for particularly notable cases. You wouldn't be able, to example, to change venue, which also comes kind of from the same Wren word, right? You wouldn't be able to change venue because you'd be fixed to, say, the county or the location. So that might pose a problem. Now, maybe that problem is acceptable to you or not, because you're trying to debate, is this okay or not? So is it acceptable to you if the jury of the population just happens to really, really hate your guts before you start? Is that adequately fair to the defendant? And I suppose you could say it is, because you're just making a conclusion at the end of the day. Is it fair, like fundamentally, if the jury just super hates you before you ever start, and they all think you're super guilty before you ever start, is it fair for that to be your jury? Maybe it is fair because that's just the jury of your peers, and maybe that's fair. Or maybe it's not fair because they're too biased. Or maybe their bias doesn't matter in this context because they are the people, and the people cannot be wrong. You know, you could come to all kinds of conclusions, but this is sort of the things that they're debating on the issue. Okay? Fine. It was proposed to insert the word after juries with the accustomed requisites, leaving the definition to be construed according to the judgment of professional men. Even this could not be obtained. The Senate suppose all that the provision for vicinage in the judiciary bill will be sufficient to quiet the fears were called for the amendment at this point. The version that finally emerged from the Constitution was the following: ensured the right to a speedy and the right to a speedy and public trial by an impartial jury of the state and district, and here they're referring to federal districts, wherein the crime shall have been committed, which district shall have been previously ascertained by law. Fine. Gone were the provisions spelling out such common law features of the jury as unanimity or custom requisites. And the vicinage requirement itself had been replaced by wording that reflected a compromise between broad and narrow terms of the definition and left Congress the power to determine the actual size of the vicinage by the creation of the federal judicial districts, which is still the law today. Cool. Some states have more than one district, some states do not. Typically depends on how big they are. Three significant features may be observed in this sketch of a background. First, even though the vicinage requirement was as much a feature of the common law as it was a 12-man jury, the mere reference to a trial by jury was not interpreted to include that feature. Okay, fair enough. I mean, maybe that's a fair conclusion. So if the vicinage requirement was a feature of the common law, if that is true, then you would therefore read it as being required. But in this debate, you can see that they're debating the issue. And so it's always a little dangerous, incidentally, whether statute or not, to see things that were not adopted as referring to their intent. But there's something there. So they debated the idea of having this explicitly listed. They didn't explicitly list it, but it's a dangerous legal proposition to say that that necessarily means something, because it's failure to act, right? There was a debate about doing it. They thought about doing it. There was a discussion about doing it, but they didn't do a thing. They didn't do a thing. And so you're inferring something from their silence. You know, they didn't pass a thing that says no vicinage required. They didn't pass it saying vicinage required. They were silent kind of on the issue ultimately. And inferring anything by silence is a dangerous proposition. So I take note of that. That doesn't necessarily mean, incidentally, by the way, that doesn't necessarily mean that failing to interpret the right to a trial by jury as requiring this vicinage would be wrong. You could still come to the conclusion it's not part of the rights because of this debate, but it's a slightly dangerous proposition, so you want to be careful with that. Second, provisions that would have explicitly tie the jury to the concept of accustomed requisites of the time were eliminated. Okay. Such action is conceitedly open to the explanation that accustomed requisites were thought to be already included in the concept of a jury. Yeah. But that explanation is no more plausible than the contrary one. The deletion had some substantive effect. Again, you're inferring something by deletion, and that's problematic. Because they didn't vote on it, right? They didn't pass it. They didn't have enough votes to pass it. Well, so what does that mean? Exactly. Not action doesn't necessarily imply anything about their intent or plans for the future. So, okay, I don't know about that. Indeed, given the clear expectation that a substantive change would have been affected by the inclusion or deletion of the explicit vicinage requirement, the latter explanation is, if anything, more plausible. Okay. Finally, contemporary legislative and constitutional provisions indicate where Congress wanted to leave no doubt it was incorporating existing common law features of the jury system, it knew how to express language to that effect. Thus, the Judiciary Bill, signed by the President on the same day the House and Senate finally agreed on the form of the amendments to be submitted to the states, provided that in certain cases for a narrower vicinage requirement that the House had wanted to include in the amendments. But here at least you have contemporaneous action. It's not in the context of the Constitution, but is in context of literally a bill that's happening at exactly the same time. That is being passed by the exact same Congress. So that can be informative. Because if you're trying to understand what they meant in one thing, looking to what they did in another thing might be informative. Because presumably they're not completely contradicting themselves, unless that's clear that that's what they're doing. Presumably they are speaking with one mind. So the legislation is at least partially helpful in being informative about what's going on. This, incidentally, would be true, generally speaking, of legislation that happens closer to the time of the constitutional enactment is probably more reflective of what they were thinking at the time. That's true, incidentally, of legislation in both directions. So as you go out the number of years either way, the legislation becomes less informative in trying to understand something. But of course, that's not true where something's just existed for 400 years. So if you have a sporadic piece of legislation, it's less informative. If something's been true for 400 years, that's, less the case. But generally speaking, legislation that's closer to the time of the constitutional adoption will be more informative as to what the Constitution means, or even what another statute might mean. If Congress is passing like two bills at the same time or relatively close in time, they might have some relation to each other. They might be at least partially informative of what they're thinking. And again, you are referring to act. You're referring to something Congress did in this case. You're looking at one bill and trying to understand it in light of another bill, which is congressional action. So you're looking at them doing a thing and trying to help you understand what the other thing might mean. So that's helpful, potentially, and doesn't necessarily have the same problem of looking to silence, because you're not looking to silence. You're looking to a thing they did, just in a parallel context. Okay. Thus, the Judiciary Bill, signed by the President on the same day they said, did the narrower thing. And the Seventh Amendment, providing for a jury trial in civil cases, explicitly added that no fact tried by a jury shall otherwise be re-examined in any court other than the rules of common law. Sure. We do not pretend to be able to divine precisely what the word jury imported to the framers, the first Congress, or the states in 1789. Well, that is the right question to be asking. What the hell do they mean by that? It may well be that the usual expectation was that jury would consist of 12, and hence the most likely conclusion be drawn is simply they little thought of the specific question. Yeah, I mean, that's true. Whatever you can say about the wisdom or not of referring to the non-action as it relates to the vicinage clause, at least they were debating the idea. You just talked about it just now. There was a proposal that the amendment explicitly include this vicinage clause. There was a debate on the issue. The Senate was not a fan of this proposal, and there was a debate on the proposal. So whatever you can say by the failure to adopt it, at least they were discussing it. And so perhaps their failure to put it into the Constitution does indicate something, because obviously they were talking about it and obviously they didn't do it. And so maybe that's possibly suggestive of something, but at least they were talking about it. You're not talking about any discussion they had about 12-person juries. That does not appear to be part of the discussion. It's not like the Senate's like, whoa, now, wait a second, we only want 9-person juries, or something like that. It doesn't seem like that was something they talked about. So if it's something that's existed for 400 years, if juries have been existing for 400 years with 12-person juries, and that's what we've been doing for 1,200 years, or for 400 years, we've been doing that, at least fixed by that point. If we've been doing it for 400 years and no one's talking about it, it's probably that everyone just accepts it as a given. It's like, why discuss the water we're literally swimming in? It's the water we're swimming in. We didn't talk about it. So it was probably understood. That would be the most reasonable conclusion, I would think. But there's absolutely no indication in the intent of the framers of an explicit decision to equate the Constitution and common law characteristics of the jury. But they said the term, though. And they talked about the right to a trial by jury. So, nothing in the history suggests, then, that we do violence to the letter of the Constitution by turning to other purely historical considerations. So apparently 1970s Supreme Court does not believe in history. Okay, so they're not about the history. To determine which features of the jury system, as it then existed at common law, were preserved. This sentence is such an anathema today. It's hard to believe, right? They're like, yeah, why would we turn to purely historical considerations? Says the Supreme Court in the 1970s. And the legal commentariat in 2024 is like, what are you talking about? Yeah, so apparently we have a difference of opinion on that one over the last 50 years. So that's interesting, I suppose. For what it's worth, by the way, this was a 7-1 decision. So the Supreme Court was pretty strong on this point, but no one would write this today. No one would write this today, even if ultimately they found the history to be of little weight, or they found other factors to be more important. No one would say, who would ever turn to purely historical considerations? No one would say that today, man. Damn. The relevant inquiry as we see it must be the function that a particular feature performs and its relation to the purposes of the jury trial. You're looking to purpose? Oof. That's okay. Yeah, that's not necessarily great. And you're looking at purpose as a way to constrain the number, which doesn't even make sense, because 12 people isn't inconsistent with the purpose. I don't know, man. Measured by this standard, the 12-person requirement cannot be regarded as indispensable. Yeah. The purpose of the jury trial, as we noted in Duncan, is to prevent oppression by the government. Providing the accused with the right to be tried by a jury of his peers gave him an inestimable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge. Given this purpose, the essential feature of the jury obviously lies in the interposition between the accused and the accuser and the common sense judgment of a group of laymen, and in the community participation and shared responsibility that results from the group's determination of guilt or innocence. Fine. The performance of this role is not a function of the particular number of the body that makes it up. Okay. To be sure, the number should probably, now that's definitely a word you want in your Supreme Court decision, probably. To be sure, the number probably should be large enough to promote group deliberation, free from outside attempts at intimidation, and provide for a fair possibility for obtaining a representative cross-section of the community. Okay, but we find little reason to think that these goals are in any sense meaningfully less likely to be achieved when the number 6 than 12. And then the Supreme Court notes in the 1970s in a footnote that they take no view as to whether or not unanimous juries are required, which would ultimately be decided in Ramos versus Louisiana 50 years later. Yes, unanimous juries are required, it turns out. But they weren't sure in 1970. And also, I'm really not sure how you can conclude that 6 is meaningfully less than 12 when it comes to the factors of a large enough group to promote group deliberation, free from outside attempts at intimidation, and to provide for a fair possibility of obtaining a representative cross-section. I'm not quite sure how you can conclude that 6 is not meaningfully less than 12 when it comes to those factors. 6 seems like quite a lot less than 12 when you're looking at those factors. Just saying. And the certain reliability of the jury as a fact finder hardly seems like a function of its size. Really? Seriously? You don't think like their role of fact finder has anything to do with their size? I think it has something to do with their size, because you're trying to determine what the facts are. And the more people that agree on it, the more assurance we can have of that fact being reliable. Okay, fine. It might be suggested that a 12-man jury gives the defendant a greater advantage, since he has more chances of finding a juror who will insist on his acquittal and thus prevent a conviction. But the advantage might just as easily belong to the state, who also needs only one jury out of 12 insisting on guilt to prevent acquittal. But either way, it represents a broader consensus. So I'm not sure whether the advantage is to the defendant or to the prosecutor, but either way, getting 12 people to agree is probably more indicative of the reliability of that rather than 6. Because getting 12 people to agree would presumably be naturally harder. What few experiments have occurred, usually in the civil area, indicate there's no discernible difference between the results reached by two different sized juries. In short, neither the currently available evidence nor theory suggests that the 12-man jury is necessarily more advantageous to the defendant than a jury composed of fewer members. Sure. Similarly, why the theory of the number of viewpoints represented on a randomly selected jury ought to increase as the size of the jury increases, I would think. In practice, the difference between a 12-man and a 6-man jury in terms of cross-section of the community seems negligible. Really? It's twice as much. It's twice as many. It's 6 whole more people, man. Okay, so we want to get a cross-section of the community. We want the community to vote on this. So we want a representative cross-section. 6 is just as good as 12. Okay. Even the 12-man jury cannot ensure representation to every distinct voice, particularly given the use of peremptory challenges. As long as arbitrary exclusion of a particular class from jury rules are forbidden, which you can't discriminate on the basis of black or race or sex, for example, you can't do that. The concern that the cross-section will be significantly diminished if the juries decrease in size from 12 to 6 seems unrealistic. That just sounds like some bullshit. That just sounds like some bullshit. Yes, it's true that 12 people may not necessarily be the ideal representative cross-section of a community. 12 may be insufficient a number. But for better or worse, for whatever combination of reasons they may be, 12 was the number we landed on. 12 was the number we landed on. How? Who knows? Who knows? This was happening for 800 years, and 400 years ago, we had basically settled it in black letter. Okay? So for 800 years, we're kind of doing the 12-person thing, and 400 years ago, we're like, 12 people is the right number. And that's probably what they were referring to in the right to the trial by jury. Would 100 people be more representative of the community? I mean, almost necessarily, yes. But 12 was the number we came up with. And in the absence of intent to change that number, for whatever reason, because again, you could quibble with 12. I mean, why not 24? 24 would be twice as good, right? So why not 24? You could quibble with 12, but in the absence of the intent to change it, in the absence of the direction to change it, you would think that they meant that because that's what they were. Yeah, I mean, you know. And young black economist, you're right. Can't the same argument be made about 3 as 6? Presumably. Presumably 3. Presumably. I'm not sure why not 1. Why is 6 the bare minimum? This is the problem, incidentally. It's like, okay, if 6 is the bare minimum, why? Okay, you need, I mean, presumably you need a group, so you need more than 1, I guess. But why not 2? Or why not 3? We have 3 judge panels, sometimes even in trial courts, although that's obviously rare, but sometimes you have a 3 judge trial. It happens most often in gerrymandering cases, is a 3 judge trial court. So you can have 3 judges at trial. It can happen. It's rare, but it can happen. So why not 3-member juries? I mean, if it's good enough for the bench, it's good enough for the jury. Am I right? Am I right? So what is the minimum number? And where are you getting that from in the constitutional text or in history or tradition? Where are you getting this minimum from? On what basis? You're like, oh, it can't be any lower than 6. But why? Why can't it be any lower than 6? Where's this number coming from, 6? Are you pulling it directly out of your ass? It sounds like you're pulling it directly out of your ass. Where's the number 12 coming from? It's been around for 800 years and locked in place for 400. Oh, okay. That's a much better answer. That's a much better answer, right? We conclude, in short, as we began. The fact that the jury at common law was composed of precisely 12 is a historical accident. That may well be, although to be fair, I'm not really sure that from first principles, you can really make much of an argument concerning any of the common law. I mean, why is any of the common law the way it is? And there's probably not really a great answer other than just history. That's just what common law was. Common law was literally just judges deciding cases and then being influenced by each other and then adopting each other's decisions and until we reach some sort of consensus. But why here as opposed to somewhere else as a matter of law? There's really no real great answer to that question other than that's just what we landed on. That's just what we landed on. That's just the way it's been. Because that's the way it's going to be. And if we want to change it, I suppose we can. We can have a debate. So a common law can be changed, unless it's in the Constitution, obviously. Common law can be changed by statute, and states have changed common law, sometimes significantly, depending on what we're talking about. But they did it through like debate and discussion and all the rest of that kind of stuff. So I would think most, if not all, the common law could be just described as a historical accident. Like, why the boundary here as opposed to any other place? It just is, you know, it just has been that way for long, and people's behavior have adopted it. It's like, that's just the way we've kind of done it, in fact. It's like, okay, I mean, all right, fair. I mean, but they're not all about that historical significance or historical accident. Okay. And again, the 1970s Supreme Court discounting of history is so weird to my modern ear. I'm like, this is so strange to my modern ear. It's like, you think history is some bullshit. That is so strange to me. But okay. The 12 of common law is a historical accident unnecessary to affect the purposes of the jury system and wholly without a significance except to the mystics. Okay. To read the Sixth Amendment as forever codifying a feature so incidental to the real purpose of the amendment is to ascribe to a blind formalism to the framers that would require considerably more evidence than we've had to be able to discover in the history and language of our Constitution. Oh, history is important now? Oh, okay. Or in the reasoning of our past decisions. But your past decisions assumed it was true. And you're even deviating from your own dicta. Because your past decisions, you're like 12 people is the right number. And then when you're actually presented with your question, you're like, not so much. So you're disagreeing with yourselves, the history, the tradition, the common law, for no particular reason. No particular reason. Ookie dookie. We do not mean to intimate that legislatures can never have good reasons for concluding a 12-man jury is preferable to a smaller jury, or such conclusions reflected in the provisions of most states and our federal system are in any sense unwise. Legislatures may well have their own views about the relative value of the larger and smaller juries, and may conclude, wholly apart from the jury's primary function, it is desirable to spread the collective responsibility for the determination of guilt among this larger group. In capital cases, for example, it appears no state provides for less than 12 juries. But do they have to? I mean, even Florida has 12-person capital juries. They do use 12 people for capital crimes, but do they have to? And if so, why? Where is that coming from? A fact that suggests implicit recognition of the value of a larger body as a means of legitimizing society's decision to impose the death penalty. Our holding does no more than leave these considerations to Congress and the states, unrestrained by an interpretation of the Sixth Amendment that would forever dictate the precise number that can constitute a jury. But if it's the number, that's what they meant. If you want to say a jury does not include the vicinage clause because they actually debated it and didn't adopt it, and therefore that indicates something to you, I guess cool. And also you can inform that decision by the contemporaneous passage of the Judiciary Act itself. So fine. They actually debated the vicinage clause. They had it. There was a huge argument over it. They didn't want it. Senate thought it was too strict. And also they passed a narrower version of what it meant as statute. So even in the statute, the Judiciary Act, when they passed the vicinage clause, it was not the same as a common law. It was a narrower concept. And so you can understand, oh, okay, vicinage is not part of this thing. Just the state. The state is the new vicinage. Cool. And then later with the amendment, oh, it also has to be of the federal district. Cool. But that's understandable because you're using things they did. You're using a bill they did. You're using a debate they did. You're using something. You got nothing when it comes to 12. There's no debate, no discussion, no contemporaneous passage of a judiciary. You got nothing but crickets, baby. Nothing but crickets. Consistent with this holding, we conclude that the petitioner's Sixth Amendment rights as applied to the states through the 14th Amendment were not violated by Florida's decision to provide a 6-person rather than 12-person jury. The judgment of the Florida District Court is therefore affirmed. Yeah. And I believe there is a dissent, which I'd like to read from a little bit. So Mr. Chief Justice Berger concurs. Justice Black dissents in part. Douglas joins, dissents in part. They say dissenting in part. Oh, they dissent on the incorporation doctrine, which is fair enough, right? So they are not happy with the entire incorporation doctrine, which, fair enough. They're pulling a Justice Thomas. We're not really happy with this entire framework. Fair enough. The framework is not ideal. I don't know the juice is worth the squeeze to change it at this point, to be honest. The Privileges or Immunities Clause was a perfectly good way to do this. But at this point, given where we are and all the adoption through substantive due process, I don't know that the juice is worth the squeeze. So even if I got to the Supreme Court, I almost certainly would not overrule it, even though I'd be frustrated by it, because it's just not worth it. It's just not worth it to fix it for what is technically correct, potentially at this point, because I'm not sure there's much substantive difference in it. That's the thing. What would be the substantive difference? Why am I doing it? And if there's no substantive difference in it, it's like, okay, call Rose by any other name, I guess. And I'll just be frustrated. That's fine. So they discuss the 14th Amendment, blah, 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 and the incorporation doctrine, blah, blah, blah. We can skip that because we're not here to decide that right now. Blah, 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 more blah, blah, blah. Okay, and then they talk about the notice of alibi provision, which we also didn't discuss because that was also in this case. Does the defendant have to give a notice of their alibi in advance of them testifying? Yes. And they said, okay, that unduly interferes with my right to testify. The Supreme Court's like, no, it doesn't. Which is, fair enough as far as it goes, because you're just indicating what you're going to testify about anyway. So how does it indicate with your ability to testify? And it gives the state notice so they have an opportunity to investigate that and determine the facts, which is a good thing. So, yeah, no, you have to give notice of your alibi. Fine. So we'll skip that because we don't care. There's oh, I'm on the wrong thing. No wonder. I was scrolling the wrong document. I was confused there for a second. All right. So Justice Marshall dissents in part. However, since I believe the 14th Amendment guarantees Williams a jury of 12 to pass upon the question of his guilt and innocence before he could be sent to prison for the rest of his life, I dissent from the affirmance, which, fair enough, because the right to a jury, although I'm not necessarily educated enough to know for sure, could obviously be different between misdemeanors and felonies. So even if you had a 12-person jury requirement for felonies, I don't know the history well enough to know what the requirements are for a misdemeanor. Although I'll take note that historically felony and capital crimes were one and the same, but I digress. But either way, it's like if felonies were 12-person, that may or may not speak to a misdemeanor. But so he's like upset because this could send someone to the rest of their life. So this is too serious a crime for a 6-person jury. So essentially alluding to the idea of maybe misdemeanors don't require this, which, fair enough. Justice Marshall says, I adhere to the holding of Duncan versus Louisiana because trial to a jury in criminal case is fundamental to the American scheme of justice. The 14th Amendment guarantees the right in all criminal cases, were they to be tried in federal court, would come within the same guarantee. Fine. And I agree with the court that the same trial by jury is guaranteed. Once it's decided that a particular Bill of Rights guarantee is fundamental, the same constitutional standards apply to both the state and federal government, which has been the decision literally every single time this issue has come up, as I mentioned before. Every single time they've had this discussion. And every single time the Supreme Court said it's the same thing. Great. At the same time, I'd adhere to the decision of the court in Thompson v. Utah. The jury guaranteed the Sixth Amendment consists of 12 persons, neither more nor less. As I see it, the court has not made a convincing case the Sixth Amendment should be read differently than it was in Thompson, even if the matter before us now was de novo, much less an unbroken line of precedent going back 70 years. Yeah, so the Supreme Court says its own decisions were all dicta, which maybe they were, but 70 years of dicta, assuming it, plus 400 years of law that required it, plus 800 years of law that strongly suggested it. You know, Supreme Court is kind of ignoring a lot of things here, man. I don't know, man. Great. The arguments made by Harlan in Part 1B of the opinion persuade me that Thompson was right when decided and the state still sounds doctrine. I'm equally convinced the requirement of 12 should apply to the states. And then we have Harlan dissenting in part. Who says 12-member juries are not constitutionally required in federal criminal trials either, which they wouldn't be because they're one and the same. So that would be true, necessarily. So he writes separately to say that for some reason. Blah, 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 blah. And then he writes for a while on this about federalism and incorporation and some other stuff that, you know, is whatever. Okay. And then they discuss a little bit more about the 6-person thing, and we can stop discussing that for now. Okay, great. So that was the Supreme Court's decision back in 1970. 1970, that was decided. Okay. We will now turn our attention to Justice Gorsuch's dissent from a denial of cert, which raised this exact issue. So people are still fighting this issue, as you would expect. And Justice Gorsuch and the Supreme Court decided not to hear the case, but Justice Gorsuch wrote some thoughts on the issue. So I'll read what Justice Gorsuch had to say. Justice Gorsuch notes the petition for the right of certiorari is denied. Justice Gorsuch writing from dissent of denial. From almost all this nation's history and centuries before, the right to trial by jury for serious criminal offenses meant the right to 12. And by serious, we're talking felonies. Again, not taking a position right now on misdemeanors. Maybe less than 12 is okay for misdemeanors. Maybe that's fine. But that's not what we're talking about right now. We're talking about serious felonies. Great. Acutely concerned with the individual's and liberty, the framers of the Constitution sought to preserve this right for future generations. Yet today, a small number of states refuse to honor the promise. Consider this case. A Florida court sent Tonya Cunningham to prison for 8 years on the say of just 6 people. Florida does what the Constitution forbids because of us. In Williams versus Florida, this court in 1970 issued a revolutionary decision approving for the first time the use of 6-member panels in criminal cases. In doing so, the court turned its back on the original meaning of the Constitution, centuries of historical practice, and the battery of the court's precedents. Before Williams, this court had said it was not open to question that a jury should consist of 12. In 1930, they said that. We had understood the jury referred to in the original Constitution and the Sixth Amendment is a jury construed, as it was of common law, of 12 people. Sounds about right. Really, given the history of jury trial right before Williams, it was nearly unthinkable to suggest the Sixth Amendment right to a trial by jury is satisfied by any lesser number. Yet Williams made the unthinkable a reality. In doing so, it substituted bad social science for careful attention to the Constitution's original meaning, which is the thing, right? We need to figure out what the Constitution means. So, yeah, the social science studies are going to be not particularly helpful towards that endeavor. Pointing to academic studies, Williams tepidly predicted that 6-member panels would probably deliberate just as carefully as 12. I did take note. The word probably was not exactly encouraging in the Supreme Court. It'll probably be fine. That's definitely what you want in your Supreme Court decision. Yeah, probably okay. But almost before the ink could dry, the social studies on which it came to rely came under scrutiny. Soon after, the court was forced to acknowledge empirical data suggesting that, in fact, smaller jurors are less likely to foster effective group deliberations and may not produce as reliable or accurate decisions as a larger one. All in all, Williams was an embarrassing mistake. Wrong the day it was decided. Yeah. Respectfully, we should have granted review in Miss Cunningham's case to reconsider Williams. In the years since that decision, our cases have insisted repeatedly the right to a trial by jury should mean no less today and afford no fewer protections for individual liberty than it did in the nation's founding. Makes sense to me. It is the right to a trial by jury. It should mean the exact same thing it did in 1789. That's when it should mean. I got it. No problem. Repeatedly, our cases have warned about the dangers posed by a gradual erosion of that right. Yet when called upon today to address our own role in eroding that right, we decline to do so. Worse still, in the last 2 years, we have now twice turned away thoughtful petitions asking us to correct our mistake in Williams. If there are not yet 4 votes on this court to take up the question of whether Williams should be overruled, I can only hope someday there will be. In the meantime, nothing prevents the people of Florida and other states affected from revisiting their jury practice to ensure no government in this country may send a person to prison without the unanimous consent of 12 of their peers. If we will not presently shoulder the burden of correcting our mistake, they have the power to do so. For no less than this court, the American people serve as guardians of our Constitution, which fair enough as far as it goes. Cool. So that explains why Florida has 12-person juries. Somehow, some way, at some time, I'm not sure why. You'd have to go presumably to the debates of the legislature when they were passing this thing in the first place. At some point, they decided that 6-people jury would be fine. I'm not sure why they thought so, but apparently they did. And the U.S. Supreme Court in 1970 rather, said 6-people juries are just fine because 6 is just as good as 12, don't you know? Which even if that's true, which is totally not, but even if it's true, the number's 12. It might be a historical accident. It might be a mistake. It might be odd. It might be a lot of things, but 12 was the number, and the number is 12. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. That kind of thing. But here we have problems counting that high. I'm not so sure why. So I'm not sure if there's any further discussions on this thing, but if there are there any questions? Or we could also, if there are any questions about last night's verdict or anything else I can answer. The defendant last night, the Ballerina, was convicted of manslaughter, typically a second-degree felony. However, the use of a firearm kicks it up to a first-degree felony, typically a max of 15 years. However, the use of a firearm kicks it up to a max of 30 years. 11 and a half is the presumptive minimum sentence established by law. The judge can only deviate below that for substantial good cause, which I don't think exists in this case. So 11 and a half to 30, and I would expect something roughly in the middle. This is probably not the most severe case, doesn't necessarily warrant the highest thing, but it's also not a case where there would be significant mitigating factors that would suggest the lowest on the term. So I was thinking somewhere in the middle would probably be where we'll land. What are you missing? Her case looked like self-defense to you? It comes down to, at least in my humble opinion, it comes down to whether or not you believe her or not. And also, even if you do believe her, whether or not you believe that's sufficient legally for justification, I suppose. But the only person who has any testimony to offer, the only evidence about what happened in that house is her. This is a she said case. So this comes down to her credibility and whether or not you believe her about what happened in that house. And to my mind, I don't believe her. I found her performance to be performative. I found it to be overwrought. I found it to be deceptive. She never broke down in tears when she cried, so it didn't seem to reflect a genuine emotion. Also, although we actually did see the images in closing, we saw the images with the photos. It's like, if that's a photo of a woman that's been hit, man, I can't tell the difference. I can't tell the difference. She's like, oh, he hit me. He hit me in the face. It's like, if that's a photo of a woman being hit in the face, I can't tell the difference between that photo and a photo who's not hit in the face. So I did not see any evidence of a hit. And I didn't see, and also the marks on her belly from the box, didn't seem to suggest a level of threat that was sufficient to my mind. But that's where I came down. I thought it was guilt because I didn't believe her. This gets a lot into her credibility and whether or not you believe her or not. So that's the factor. Yeah, you could see swelling, but not much. My kid's face was worth getting hit with a basketball. Yeah, I couldn't even really see swelling. I could see maybe some kind of distortion, like below her eye, but that isn't necessarily swelling. It could just be that, could just be anything. It could be literally anything. So, since your husband passed, I can no longer cry. Be careful of perception. Well, be that as it may, if you're asking me as a member of the jury to try to discuss her, try to determine whether or not she's testifying truthfully, that was one of the indicia that indicated to me that she wasn't. If that's not an indicia that you would use, perhaps you would use other indicia. I can't really speak to how you would judge her credibility or not. I found it to be a factor that led to me not believing her that the story was genuine. Does the punishment of increasing punishment based somehow prejudice the Second Amendment? No. The right to keep and bear arms does not include any right to use it in an unlawful manner. No, I can't see how increasing it because it's a gun has anything to do with the Second Amendment. The right to keep and bear arms is a serious right, and one that you need to bear with appropriate respect because it's deadly. And holding someone responsible for exercising that right in a deadly manner, I can't see how that is a Second Amendment problem. I don't see it. If a man hits you for any reason, he'll see you in chat from Vietnam. Okay, noted. I will simply note as a matter of law that you can only use deadly force in response to deadly force, and not every hit is necessarily deadly force. So to the extent you care, I will note that this is true whether it's a man versus woman, man versus man, woman versus woman. This is the same. You can only use deadly force in response to deadly force. So if he merely slaps you, that doesn't give you the right to pull a gun. And because if it did, that would mean if she merely slaps you, it would give him the right to pull to a gun. Because this would be this logically needs to go both ways. So is a slap across the face deadly force or not? Right? You can't really split this based on gender. That's not reasonable. Men and women are the same legally under law, of course. So being equal under law means we have to judge it equally. So a slap across the face, I'm not saying it's good. I'm not saying a slap across the face isn't good. I'm not even saying it's not criminal. It's definitely not. It's definitely bad, and it's definitely criminal, and it's definitely domestic violence, And it's definitely cause to divorce, and it's definitely cause to use non-lethal self-defense in your own defense. It is all those things. But it is not cause to use deadly force, because that would be problematic at best. Can you brandish but not fire the firearm? Typically, no. No. Because the brandishing is considered itself is considered deadly force. Because again, that goes both ways, right? Brandishing is displaying with intent to intimidate. That's brandishing, right? As opposed to merely displaying. Because if you're open carrying, you're open carrying. Open carry is not brandishing. Brandishing is displaying a firearm in a way as to intimidate. Well, you're intimidating with deadly force now. And so the act of brandishing may very well warrant deadly force, because if they're brandishing, they're indicating an intent. They're indicating the intent to indicate the threat. And it's happening right now. So I would say that using deadly force in response to brandishing is warranted. If using deadly force in response to brandishing is warranted, that means brandishing itself is deadly force. It would have to be. Because you can only use deadly force in response to deadly force. So if you can use deadly force in response to brandishing, it must be the case that brandishing is in and of itself deadly force, which means you can't brandish unless there's deadly force first, because now you're escalating. You're going from non-deadly force to deadly force, right? This is just all logic chain, right? This is all logic chain. Should someone brandishing, is that sufficient for you to use deadly force? Well, brandishing is by definition displaying the firearm with the threat. That's what it is. So is that sufficient? Sure, it's an imminent threat of deadly force. So therefore, you can use deadly force because it is deadly force, but it is deadly force, which means you can't use it in response to non-deadly force, because that would be unauthorized. What if it had been an intruder and she shot him and she punished him for knowing him before he tried to attack her? She is bound by her own knowledge, is the better way to put it. She is bound by her own knowledge. This is true, incidentally, across the board. You can't lock yourself into self-defense, and you can't get unlucky in self-defense either. So you can't lock yourself into self-defense. This is true. You can't shoot someone because they had a gun if you didn't know they had a gun. But they had a gun, but you didn't know that. So you didn't have the basis of knowledge for the threat, right? You can't luck yourself. And if the gun turned out to be, for example, a fake, right? It isn't really a gun, or it wasn't really loaded, or whatever, that also doesn't work the other way around. You don't get unlucky either. Because if it's reasonable in that moment to believe it's a real gun, if that's reasonable, the fact that it was in fact fake, the fact that it was in fact unloaded, doesn't change the analysis either. So you can't get lucky or unlucky. And everything is based on what you know. It's all based on what you know. And that's obviously based on the full knowledge of what you know. So what you know about a stranger is going to be more of a fog of uncertainty, as opposed to a person you know, in which case their actions would be more informative. I'm not sure what kind of friend this is, incidentally, but if you had a friend that had a track record of brandishing their firearm and everyone treated it like a joke all the time, including you, this is a very strange friend. Don't fight the hypothetical. Okay, if you had a friend who is just known for waving their gun around all the time, and everyone's like, ha ha ha, funny joke, including you, then the next time that they brandish their firearm and wave it all around, you'd have a pretty hard time claiming that you were subjectively in fear, because you've treated it every time up to now like a joke. And so why would this be any different? What about it is different, right? So you're bound by your own knowledge. And incidentally, that also goes the other way too. If this person has a propensity for violence, right, this very same action that would seem less threatening might be interpreted as more threatening. So the action can be understood as less threatening based on the person, can be deemed as more threatening based on the person. Your knowledge of the poor person is informative about the nature of what's happening. So that's true. So you are bound by your own knowledge either way. And you are limited by your own knowledge either way. Because it all goes to what you know, which goes to your subjective sense of fear, for example. Yeah. So the lady who threw the pot of water was brandishing his weapon after threatening to shoot her, and the face was justified. That's a tough one. Although we haven't released the edited video yet, because Nate and I did a video together on this. That case with the woman with the boiling water, that is a tough one. That's a tough one on the law. That is really weird, because it depends a lot where you draw the line about where the sequence of things starts and stops. And it's going to be very tricky, I think. That is a very borderline case about whether or not he's justified or not. So for those of you who didn't see the video, this woman calls someone for a prowler. She says people are prowling. The police come to the door, knock on the door, she answers. And at least in my view, her interactions with the police indicate some kind of mental problem of hers, in my humble opinion. Her responses are not reasonable. They're not wild, batshit crazy, but they're also not sane. So that's also informative, incidentally, because again, it goes to the officer's knowledge base. The reason I mention it is because it goes to the officer's knowledge base, because actions that might be interpreted one way if they were done by a normal person might be interpreted differently if they're done by a crazy person. And that would be a very reasonable thing for you to do, because they're crazy. So you're going to interpret their actions with more circumspect, I would imagine. So anyways, the police got into the house, and and that's how they got into the house is also a little unclear, incidentally. They're asking her for her name, which she doesn't know, apparently. And then they're like, do you have ID? And she doesn't know where that is. Things are not going well. There's a pot of boiling water on the stove. You see the stove on with the gas on. So it's clearly on. The water's on, which again goes to the informative knowledge state. Is the water hot? We see the burner on, so we can reasonably believe the water's hot. And the cops say, could you turn the burner off? She then proceeds to move the pot, which isn't what the cops asked her to do. And the cops back up a little bit. And they're like, I forget exactly what the cops say, but they're like, I think she said, like, why are you backing up? And the cops kind of make some sort of like half-hearted joke. It's like, well, because we're concerned about the boiling water. And then the next words out of her mouth come be like, she says, in Jesus's name, I rebuke you. And like, dude, what the fuck, right? This is not, it's like, okay, so given the fact that there's a pot of boiling water and she just said, in Jesus' name, I rebuke you, you can reasonably interpret this as potentially threatening. The cop then pulls his gun and says, if you do that, I'm going to shoot you in the middle of your face. So this is questionable. This is questionable about whether or not this is warranted or not. This is questionable. But in any case, she then says, I'm sorry. She puts her hands up and gets down to the floor. The cops, but she's behind the kitchen counter. She's behind the kitchen counter. Okay, so the view of her is obstructed by the kitchen counter. So the police then move closer to her so they can see her, because you never know what's behind that counter or why she's going behind the counter. So they start to move closer to her so that they can, see what the hell's going on behind that counter. She then picks up the pot of boiling water and is in the process of throwing it at the cop when the cop then fires 3 times, killing her. That is a tough case. That is a tough case. It's because it gets down to and she had put the water down at one point, which also makes things challenging because it arguably breaks the chain of causation by putting it down. So she arguably breaks the chain of causation. So it depends where you draw the line, right? It depends where you draw the line in the sequence of things. If you draw the line at the moment the shots are fired, then it's a justification. It is justified if you draw the line at the moment the shots are fired. The reason for that is that you can see the pot of water being thrown in the second body cam, not the first, incidentally. So if you have no idea what I'm talking about, there was a second body cam from the other officer that was released that showed a different angle. So in the first body cam, you can't see her throwing the pot of water. So if you're like, I have no idea what you're talking about, there's a second body cam. The second body cam wasn't recording most of the interaction, but it was recording the moment in question. Because it seems like what happened is that the officer pressed the button on his body cam, and when you do that, most body cams have like a 30-second buffer or something. So anyways, it recorded this critical moment from the second body cam. So if you draw the line at him firing the shots, it's justified. The reason for that is you can use deadly force in response to deadly force. Deadly force is defined as an imminent threat or ongoing threat that poses a substantial risk of death or grievous bodily harm. Boiling water is grievous bodily harm. If you throw boiling water on someone, that's pretty much grievous bodily harm. Grievous bodily harm is defined as a serious injury. It's defined as a non-trivial injury. It's defined at least as a permanent injury. Boiling water can cause all these things. Boiling water is serious. That's some hardcore shit. So the boiling water is an imminent threat of serious bodily harm. It therefore is deadly force. Therefore, shooting, which is also deadly force, is an appropriate response to the deadly force. That's if you draw the line at that step. But if you go back in time and you go potentially to, for example, him pulling the gun, now things are a lot murkier. Because she didn't have the pot of water in her hand at that point, I don't think. So as we said, he's brandishing. He's obviously displaying the gun with a threat of imminent death. So he's arguably brandishing, which arguably could give her a basis of self-defense, except she had put the water down and she retreated by getting down on the floor. And you can't do that. You can't retreat from the encounter, which arguably she did. And now she's reinstigating. So it's a very, very messy factual thing. I think it's going to largely, although not entirely, boil down to the training practices of the police officers in question, specifically whether or not he was reasonable in a legal sense for brandishing his firearm in that moment, which is going to be one hell of a factual dispute, I would imagine. Should be really, really interesting to see. It should be really, really interesting to see. But that's what I think right now, based on the legal analysis. That's my tentative opinion. So I am a soft, I don't even know what I think right now. It's so close. It's hard to know. Yeah, it's tough. It's tough. It's tough. That's what I think right now. But I imagine we're going to have further debates on the law on this issue going forward, because it's a really interesting fact pattern. It's a very interesting fact pattern. What else can I answer for you? There was such a big distance between them? Not enough, man. Not enough. First of all, I'm not sure how much distance there really was, because I'm not sure how faithful the camera necessarily is in displaying that distance, which isn't a knock, incidentally. Cameras sometimes can have lenses that distort distances. So first of all, I'm not sure that that is necessarily indicative of how close they were or not. Secondly, no, not really. I mean, she was throwing that pot of water with all her might. The water did spill on the floor. It got like halfway, basically, between them. So I was like, no, they were in the splash zone. They were in the splash zone. I mean, look at it this way. Look at it this way. You know, let's break it in this context. Okay, you're a woman. You're a woman, and your husband is that distance away from you, and he starts to throw a pot of boiling water at you. Do you think you're justified in fearing for your life at that moment, or don't you? And if it's true of a woman, why wouldn't it be true of a man? So, what are we talking about exactly, right? Taser's an option. This isn't the question about what else he could have done. The question is about what he did do. Sure, there were other options he could have employed. That's not the relevant question. It never is. The question is whether or not the step you took was lawful or not. Not what did you have other means at your disposal. That's never the question. Can you wear a cowboy hat in court? Texas allows for it. I'm not so sure about other states. The other cop was snooping in a room? No, that doesn't seem to be what was happening. The other cop was clearing the room. He was checking for potential other people in the house, which is standard police practice. He popped his head in to go look in the room. Also, incidentally, and not for nothing, even if that was somehow unlawful, it doesn't change the calculus, because it would be trespassing. But that doesn't authorize lethal force. It authorizes non-lethal force. Bouncers do it all the time. You can use non-lethal force to effectuate a trespass, but not lethal force. It's a very close case, though. It's a very close case. I think it's going to come down to training and practices. And I think it's going to come down to where do you draw the line and sort of where does time start? And probably boils down to, no pun intended, largely whether or not pulling that gun was proper or not. Tough case. Tough case on the facts. Tough case on the law. Tough case. What was up with the sketchy hand signal directing the second officer into the kitchen in the first place? Nothing. It's communication by nonverbal means. I don't know what you mean. I don't know. Even if he could step back out of the water range, it's legit. Sure. That would get into stand your ground or not. And even then, the question would be whether or not you can effectuate, even in a, first of all, police don't ever have a duty to retreat, because that's in the nature of being a police officer, because that would be really freaking dumb. So even in states where there is a duty to retreat, generally speaking, the police don't have a duty to retreat, because the police, if anything, have a duty to run into the conflict. That's in the nature of their duty, because they're law enforcement, right? If police had a duty to retreat, like the guy pulls a gun, right? The bad guy pulls a gun, and assuming the cop could retreat, they're like, okay, we got to back out now, right? That doesn't really make any sense. So there's no duty to retreat for a cop in any event. And even if there were a duty to retreat, you only can do so if you're in complete safety, plus in the time that's available, which there's no time. So if it's an instinctual reaction, that's valid. So Again, it's also not about what he could have done. It's about what he did do. Could he have backed out of the way? Could he have used a taser? Yeah, there's a lot of things he could have done. Would some of those things potentially be better ideas? Not disputing that. The question is whether or not what he did was lawful, were his choices lawful, not whether other choices were lawful, not whether or not there are better ideas. Was the choice he made lawful? That's the question. She threw it before his gun was out? No, she didn't. She did not throw it before the gun was out. The gun was out first. The gun was out first. She did not throw it before the gun was out. No. The guy drew the gun when she was in the process of moving the water towards the sink, which was closer to them. After she said, "I will rebuke you in the name of Jesus," which in the broader context of her other behavior, I interpreted it as a threat. Again, to me, this woman, at least to me, in my mind, based on her other behavior during that scene, she is not completely mentally stable. So I interpreted, "I will rebuke you in the name of Jesus" as a threat with the boiling water. I think that is a very reasonable conclusion in that moment. Yeah. Which goes a long way towards the reasonableness of his actions, because the reasonableness of his actions is informed by his knowledge, which is informed by her behavior, blah, 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 right? I would interpret it as a threat. I think you would interpret it as a threat. If there was someone who was acting not completely mentally stable and they had a pot of boiling water and you said something slightly off and they said, "I rebuke you in the name of Jesus," I think you might fear for your life. I think you might be like, time to back out of this situation. But of course, with the police, that again isn't necessarily what they're supposed to do. They're not necessarily just supposed to run away from every situation that poses a threat, because they are by their nature supposed to confront the threat, not run away from the threat. So, yeah. It's complicated. It's complicated. It should be a really interesting trial, I think. It should be a really interesting trial. Cohen versus California determined First Amendment allows for freedom of expression, therefore hats are in. I'm not sure if that necessarily flows from Cohen versus California, but I appreciate your effort. Maybe I'll give that a go if it ever comes up. Tough case. Tough case. Anything else I can answer for you? I'm enjoying this conversation. I might excerpt that discussion about the shooting and maybe put in video about it, because that might make good for a good edited video today. So I might excerpt that and make a video about it. That sounds fun. What's next on the docket of cases? No immediate plans. Although later today we're probably going to be doing Sarah Boone's letter, because that's hilarious with her motions. That sounds like a good time. So probably later today we'll do Sarah Boone. That'll be good. Yeah. It's tough. It's a tough case, man. Not a fun fact pattern. Not a fun fact pattern. She decided to start the boiling water at 1 a.m. in order to call the police to her residence, in order to scald them. I never said any such thing. I never said any such thing. I don't know why she made a pot of boiling water. I never speculated why she made a pot of boiling water. I simply noted there was a pot of boiling water. I don't know what her motivations were. Neither do you. You can only make decisions based on what you know and what the cop knew. So, yeah, that's unduly speculative. She was clearly afraid of the officers, as evidenced by her reluctance to 911. There was no basis for her fear in that moment. The cops were, up until everything went completely to shit, behaving in a perfectly professional and reasonable way. There was no reason for her fear. Plus, they were there at her request in the first place. So that doesn't even make sense. All right, I think we've exhausted this topic for now, so I'm going to go ahead and sign off. And I've appreciated your time, and I hope you've enjoyed this. So that's some good stuff. All right. I think I'm going to just do a little intro here to record for the edited video. I'm not sure how I'm going to do this now. We'll see if this works even as an intro. A woman called the police to her house for a prowler, but winds up being shot by the police in her home. Is it murder or is it justified? Let's discuss some of the facts in this case. I don't know if that'll work, but we'll give it a shot. All right, until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.